So I believe everybody is ready, so maybe we can kick off the lecture. Good evening, good afternoon, ladies and gentlemen. Welcome to International Law Lecture Series, hosted by School of International Law, China University Political Science and Law. My name is Qingjiang. I'm a professor of law and the dean of the school. I'm most delighted and honored to introduce today's speakers, Mr. Wolfgang Kumberg and Mr. Joe Evans. Wolfgang Kumberg is a leading internationally recognized independent arbitrator and a mediator practicing globally out of London, Washington, D.C., and Abu Dhabi. Wolf has over 30 years' experience in complex commercial dispute settlement within international business circle, with a particular focus on maritime, aviation, defense, technology, cyberspace, engineering infrastructure, energy, oil and gas, and investor-state dispute resolution. Before establishing his ADR practice, he served as legal director and assistant corporate industries incorporation. During his international career, he was located in the Toronto, Zurich, and London offices. He is a thought leader in the development of investor-state mediation. Mr. Joe Evans is a PhD candidate in comparative law at China University Political Science and Law. And an independent secretary, specializing in international arbitration for over 3 years, and has experience in disputes settlement across a range of industries. He is a CEDAR accredited and International Mediation Institute qualified mediator, trained in advanced negotiation and unconscious bias by Harvard University. And he regularly judges negotiation mediation competitions in the UK and abroad. Today's lecture is titled The Use of Mediation in Investor-State Dispute. Now I would like to give the floor to Mr. Kumberg. Please.
Thank you very much, Professor Kong. It's a privilege and an honor to be here with you today to discuss what I think is a very important topic. And I'm very grateful to my colleague, Joel Evans, for having arranged this lecture for us. And what Joel and I will try to do in the next hour is to review with everyone what is actually occurring in investor-state in the investor-state world, but in particular, what's occurring with respect to investor-state mediation and the use of mediation in a forum which traditionally has utilized arbitration as its dispute resolution mechanism. So we will explore this a little bit generally, the development of mediation in investor-state disputes, but we will then also explore the development in China itself, because there has been a lot of activity and growth in mediation commercially in China, but China has also been leading with respect to the use of mediation in investor-state disputes. So we'd like to explore that a little bit more and perhaps some of the newer developments that are occurring in that area. as well. But to begin with, I think, and I don't know how many of the participants are familiar with mediation, and we thought it would be very helpful if we could start by at least creating the basis for the mediation process and talking a little bit about that. So let me just share with you my screen, and if I can, let me just get this up for you. And let's just talk a little bit about mediation and where mediation fits in the dispute resolution spectrum. As we know, in dispute resolution, we have well-established adjudicative processes where a third-party judge or arbitrator imposes a decision on the parties. And that's where the parties no longer have control of the process, but rather it is a third party that will make a determination for them. But there are non-binding means of dispute resolution as well, and probably the one that is best known is mediation. So mediation is not an adjudicative form of dispute resolution. The mediator or mediators, if there's more than one, do not actually render a decision or a determination. Rather, they work with the parties to try to assist the parties to find a negotiated settlement of the dispute. So if we look at the definition of what a mediator is and what the mediation process is, the mediation process is a flexible process. It's generally a confidential process where the parties are able to discuss matters in dispute confidentially with each other. And there is a neutral person or persons, if there are more than one mediator, who have no stake in the dispute itself, that works with and assists the parties in finding a solution to the issues that have arisen between them. So we say for mediation, the parties maintain control of the process because they can decide whether they settle or they don't settle, the terms upon which they settle. That's all decided by the parties themselves and not by a third party judge or arbitrator. So if we look at the litigation process, it's one that has very specific rules. It looks at the rights of the parties, and it looks at the past, what happened in the past. And mediation, we say, is a much more flexible process. It looks not at the rights so much of the parties, but rather what are the parties' interests? What do they need in order to resolve the dispute? And that's the discussion that takes place with the mediator. And it looks really into the future, trying to see how the dispute can be resolved and move on to the future relationship between the parties. And whether there is a relationship or not, that's something the parties can then decide. The other important thing with respect to mediation is that it's a process which is typically much faster than either a court or arbitration process. And as a result of that is also less costly. So those are advantages that mediation bring to the table. And just very quickly, the phases of the mediation process, just so that you understand it, there's a preparation phase where the parties and the mediator prepare for the mediation, discuss who's going to be attending the mediation, discuss where the mediation is going to take place, and whether there are any other peripheral parties that should take part in the mediation. For example, should experts be involved in the mediation as well? During the mediation itself, there's typically an opening phase of the mediation where the parties explain to each other what they feel the dispute is about. And the mediator is the chairperson for that meeting. And then there's the ability for the parties to explore with the mediator what the dispute is really all about, and start discussing their interests and what they need in order to resolve the dispute. And there is then a bargaining phase where the parties discuss with each other and the mediator what it is they're trying to achieve through the mediation, and try to find options and solutions through bargaining with each other, including the mediator themselves. And then there's a conclusion, and typically that will then end in a settlement between the parties, because mediation, and I think generally across the world, when we look at statistics for mediation, certainly more than half the cases that go to mediation resolve in a settlement. And so mediation is quite successful in that way. But I'd like to talk, perhaps turn now to Joel, and Joel can speak a little bit about mediation in the Chinese context and what's been happening with mediation in China generally. Joel?
Wolf, for that, and also thank you, Professor Kong, for having us. It's a great privilege for me to participate in this lecture today. In terms of mediation in China, it's worth remembering that mediation means different things to different countries around the world. And when we think of mediation in the UK, we're typically thinking of a facilitative negotiation, a facilitative model for mediation, whereby the decisions are left for the parties themselves to resolve the dispute. The mediator is not playing an active role in pushing the parties towards settlement, and the mediator is also not offering a view and evaluating the merits of the case. So that's what we are thinking of when we talk about mediation in the UK. In China, the word mediation, 调解, has a very different meaning. It has a more of an evaluative context behind it, and a meaning to it. And that is to say that a mediator in China is typically having a view on the case. They are pushing the parties to settle sometimes. They are evaluating the strengths or weaknesses of the case. And this is seen in China's judicial system in the courts, where the judge will take a view and try and push the parties to settle, which is a common feature of China's judicial system, and not a surprise when you think of the fact that China has a population of 1.4 billion people, that the judges would be trying to settle cases to make sure that the judicial system can effectively run. But it's not just judges. Arbitrators as well will often act as a mediator during proceedings. And in fact, Article 51 of the PRC arbitration law provides the legal basis for arbitrators to act as mediator in China. So it's a very common thing for a judge or an arbitrator to act as a mediator, but that is done in an evaluative way, not like the sort of Western facilitative model. In terms of more generally mediation in China, China has a long history of using mediation to resolve disputes, and it has done so for a very, very long time. And there are cultural explanations for this. That is to say that in Chinese culture, heavily influenced by Confucius, not with an emphasis on not formally adjudicating disputes and peacefully resolving disputes between disputing neighbors, for example, or anyone in a legal dispute. China has used mediation for hundreds of years, and it's very popular in China to use of mediation. I think another thing that's worth remembering is that in terms of what's happening on the ground in China from a government perspective, we've seen China sign the Singapore Convention on the day that it was available for signature, which shows that the Chinese government at least is a strong supporter of mediation. It's taken a while for the UK to show its intentions to sign the Singapore Convention, but China did it on the day that it was available for signature, which further shows China's support for mediation. I think another thing is that whilst China doesn't have a commercial mediation law, a formal commercial mediation law, Chinese arbitration institutions have developed mediation mechanisms and are offering a mediation service for quite some time. And as China tries to position itself as an international dispute resolution hub, the use of mediation is only going to increase in China, and China will be a venue for the resolution of international disputes through mediation going forward. Thanks, Wolf.
Thank you very much, Joel. And that's actually very interesting. And my own experience with mediation in China is much as you say, Joel, that there is much more emphasis on the mediators being involved in attempting to find options for the parties to resolve their dispute and perhaps play a more active role than traditionally has been played by the mediator in perhaps the Western model of mediation. Although I must say, through my own experience, I've been involved in mediation for over 20 years now, that is changing as well. And I think if you speak to most mediators today, they're going to say that they use a combination of different skill sets to bring the parties to a resolution. And so I think mediators do play a more active role now in the Western model as well. And I think it really depends on the expectations of the parties. And I think the mediators will always discuss with parties, the style of mediation that they're looking for to ensure that they can provide that to the parties in the mediation process itself. So it's interesting how that has evolved, but I know that in China in particular, that more interventionist perhaps model is utilized. So that's important to make that distinction. Perhaps we can talk a little bit, Joel, about the ISDS context and how that has evolved as well to incorporate mediation. So the investor-state dispute system has been one that's developed over certainly the last 50 years or so through the World Bank and ICSID being the dispute resolution branch of the World Bank. And these types of disputes between states and investors, of course, are very unique disputes because unlike two commercial parties, they involve a sovereign state as well. And the sovereign state, through bilateral investment treaties, has given up certain of its sovereign rights to enable investors directly to bring claims against the state. So it's a very particular type of dispute mechanism that is utilized. And through certainly ICSID, these disputes have largely been dealt with through arbitration. And while ICSID always also had conciliation rules, these rules have not been utilized very frequently, largely because there is a process whereby the parties get a non-binding recommendation from a tribunal. It's not something that is binding, and so parties have generally opted to go the arbitration route and have brought arbitration proceedings against states. It's interesting that the bilateral investment treaties, and there have been several studies looking at them globally, they have always had generally, and many of them have had, not all of them, but many of them have had conciliation provision in them, so that before parties could commence arbitration, they were meant to see whether they could either directly negotiate or through a form of conciliation try to resolve the dispute. And so generally these bilateral investment treaties have a period for that to take place. It could be 3 to 6 months generally, where there is at least a period of time carved out for discussion and negotiation. In reality, that doesn't often occur. There may be negotiations, certainly, but often parties are simply using that time to prepare for arbitration. So what has been looked at and has been developing really over the last 5-6 years is whether, in fact, during that period, mediation might not be something that could also be attempted. And so there has been a move, even in the drafting of the modern bilateral investment treaties, to see whether mediation provisions couldn't be included. And I think statistically, the last time this was reviewed, there are about 51 or so modern bilateral investment treaties that actually include a mediation provision. It's generally a provision which is, again, consensual, because mediation overall is usually consensual. The parties agree to it. So it's not forced on the parties. There are only 2 or 3 that require mediation before you go to arbitration. But there is certainly this move now within the ISDS community to include mediation in the process itself. And Joel, I mean, you might want to talk a little bit about UNCITRAL and what China is doing within the UNCITRAL 3 process, which is actually looking at the modernization of ISDS and changes that can be brought into ISDS. So that is still occurring right now. And I know China has taken quite a robust position there. Joel?
Yeah, that's right, Wolf. China, unsurprisingly, after having signed the Singapore Convention, is a very firm supporter of investor-state mediation, and in fact, in its submissions to UNCITRAL Working Group 3, which is the working group tasked with the difficult job of reforming investor-state dispute settlement, the Chinese government actively promoted the use of investor-state mediation and said that mediators provide more opportunities to adopting creative and forward-looking methods to promote the settlement of investment disputes. So that's a quote from the Chinese government's submission. But they also went further and said that the establishment of a more effective investment mediation mechanism should be actively explored. So from the Chinese government's perspective, mediation of investor-state disputes is a very positive thing. It's an innovative addition to the ISDS procedure, as many of you will know, there has been a debate about the legitimacy of ISDS as a result of increased costs through arbitration, length of time receiving an award, possible inconsistent decisions regarding the same facts and the same law, and also by a sort of an issue with diversity amongst the pool of arbitrators. So this is something that investor-state mediation can address. It might not be able to fix everything. Nobody's saying it's a perfect form of ADR because, quite frankly, there isn't one. But there is a growing interest in the use of mediation in investment disputes, and China, the Chinese government itself is actively promoting that. I think one other thing to say is that I mentioned earlier that Chinese parties would really prefer to negotiate and mediate as opposed to adjudicate a case. And that might be to do with many issues, but culturally speaking, I think, as I said, the culture of mediation in China is strong. So that'd be one of the reasons. If you look at the statistics, China has been involved in very few ISDS cases. And there've only been 15 cases brought on behalf of Chinese investors. And China has been on the receiving end of 9 claims itself. And this is very, very different to the US, for example, which has been involved in hundreds of cases in the capacity of claimant. And so China, which is soon to be the world's largest economy, is in very few cases in ISDS. And that further speaks to the idea and the practicality that a lot of these cases are being settled long before they crystallize into a dispute for arbitration. So from a Chinese perspective, mediation and negotiation is a very popular form of ADR, and it's being used very much so in practice, and that is being echoed by the Chinese government's response to UNCITRAL Working Group 3. Thanks.
Great, thanks, Joel. That's actually quite interesting. I mean, the fact that China itself and Chinese investors have not been involved in many ISDS claims is interesting in the context of Belt and Road, of course. I mean, there have been a lot of investments made by China. Interestingly, there have not, however, been a lot of investment claims. I mean, what do you put that down to, Joel? But why hasn't the current system really been utilized by China?
I think it's complicated to say. I think there are various factors, probably. I think, as I said earlier, probably most claims are being resolved through mediation and negotiation, and that seems to be a very popular method for resolving these types of disputes. I also think that a lot of these projects take many years to complete, so it might be that we haven't seen the full extent of the disputes in Belt and Road investments, Yeah, I think that's probably it, really. Negotiation, mediation being very popular. We haven't seen the full scale of the disputes from Belt and Road, and I think that a lot of these investments are quite important for infrastructure. So it's quite important that the project is able to be completed. Whereas if a dispute was to result in arbitration and a complete breakdown in the relationship between the parties, that would render that investment essentially totally, perhaps not worthless, but it would end the relationship between the parties. And I think that's something that the Chinese SOEs are keen to avoid, the complete breakdown of a relationship. They're keen to mediate and negotiate. And again, the Belt and Road is still ongoing. So we're probably yet to see the full extent of it.
Right. Yeah, that's interesting. I mean, we'll talk a little bit more about how China perhaps itself is trying to influence investor-state dispute resolution, perhaps through some new mechanisms outside of the ICSID system. So just to go back then to how mediation has been formalized, perhaps in ISDS. And Joel already talked about UNCITRAL and what UNCITRAL is currently looking at as part of their reforms. I think we can go back to approximately 2011. That's where we first see an attempt to start to look at mediation formally within ISDS. The International Bar Association, the IBA, actually promulgated rules in 2011, investor-state mediation rules. And that was really the first time that I know of anyway, where the mediation process was really formalized within rules that affected investor-state disputes. Those rules are still, I think, if you look at them, quite progressive, and they do set a framework within which mediation can be utilized in investment disputes. So certainly worth looking at the IBA investor-state mediation rules. They were out there, but they were not very frequently utilized because arbitration still continued to play a strong role in most of the ISDS disputes. I guess the next important development was really led by the Energy Treaty Charter, the ETC, and the Secretariat of the ETC, because the ETC, being a fairly small grouping of energy producers and transporters, and so a grouping of about 51 countries within that treaty. The Secretariat looked at whether mediation could be utilized within that treaty as well for energy disputes. And there was a conciliation provision in the treaty that the Secretariat thought would be a good place for mediation to take place within. And so the Secretariat developed a set of mediation guidelines for member states to utilize. And you can go onto the website of the Energy Charter and see the mediation guidelines that were put in place by them. And they're actually quite extensive guidelines, largely aimed at states, because, of course, the treaty involves states. And so it's something that is worth looking at even today as guidance as to how mediation can be used in investment disputes. The other thing that the Energy Charter Treaty Secretariat did was that they then also put together what they call a model instrument. States, and when you are dealing with states, of course, are made up of different organs and ministries generally within the state, and each of them typically will act under a minister. And when disputes arise, of course, disputes, particularly with investors, can involve several ministries. And states generally have not been very effective in how they're organized to deal with disputes. And so what the Energy Charter Treaty organization has really done through the Secretariat is to try to create a framework for states that they can implement in order to deal more effectively and efficiently with disputes when they arise. And part of that model instrument also includes how the state can use mediation effectively. The issue with any dispute that arises with the state is that the state itself has to organize itself so that it can deal with the dispute, that somebody has authority to deal with that dispute, and that somebody has authority also to be able to resolve that dispute. And as we know, in a bureaucracy, which a state has a lot of course, civil servants that work within the state, it's very difficult for any individual civil servant to take the responsibility to agree to settle a dispute. And so what this framework mechanism tries to do is that ahead of time, there is already then organized within the state an effective organ that deals with the dispute and has the authority to deal with the dispute, and also has the authority to resolve the dispute, or if they don't have the authority, that there is a clear line of authority that then can be utilized, and either an individual or a committee within the ministries can make a determination as to whether to settle or not to settle a dispute. And that's a very important point, because investors, of course, generally are organized very differently. They're typically companies, and companies will have a fairly clear hierarchy as to who can sign off on any particular settlement. And so it's much easier for companies to be able to organize themselves in a dispute and to determine whether they will resolve the dispute through a settlement. And so this is a very important, I think, contribution that the Energy Treaty Organization has made, and that is to this model instrument. So again, it's on their website, and it's well worth looking at. And you know, I've been helping to promote this within several states where they're looking to actually put a structure in place to deal with dispute resolution. I think ultimately very important step that was taken by ICSID last year is to actually have mediation rules. So in addition to their conciliation and arbitration rules, ICSID now has promulgated mediation rules. And I must commend Meg Kinnear, the Secretary General of ICSID, who really put a lot of effort into bringing about these rules and having the member states then adopt those rules. So it's an important progression, because given that ICSID probably deals with 80% of the ISDS claims, the fact that they now have mediation rules really enhances the credibility of mediation in the ISDS space. And that's really important. So as Joel said, we have the Singapore Mediation Convention, which states, of course, are signing up to. And that has also enhanced the credibility of mediation globally. But ICSID now adopting mediation rules also adds to that credibility. And I think it will, in the future years, enhance the use of mediation in these disputes. So speaking to states and speaking to a lot of the law firms that are involved in ISDS, they're now becoming aware that there is an additional process. I mean, arbitration will always be there, of course, ultimately, if parties can't agree a settlement. But mediation, I think, increasingly will become part of the process that's considered both by the investor and by the state as a potential means of resolving these disputes. It's interesting that there are an increasing number of states that are looking at grievance procedures for investors at a much earlier stage than where the dispute actually becomes crystallized and moves on into potentially arbitration. Of course, foreign direct investment is important to all states, but particularly since the pandemic, states are looking at how they can build their economies up again, and foreign direct investment is an important element of that. So having a grievance procedure within the state that allows investors to bring issues that have arisen in the investment forward to be resolved in some way with the state is an important part of FDI. And so there are now a number of states that are looking at utilizing mediation at an earlier stage to allow investors to raise grievances, and if they can't be resolved, to see if they can be resolved through mediation. And that, I think, will become also part of the landscape going forward. Joel, how about in China? I mean, do you see with respect to, let's say, Belt and Road investments, maybe having mediation as a grievance procedure that might be utilized?
I think it's a really good question, and certainly a possibility for Belt and Road disputes. When it comes to mediation in China, I think it's worth looking at it with the overall context that, you know, China has signed the Singapore Convention. There have also been international commercial courts established in China, in Shenzhen and Xi'an, to really offer a mediation service alongside arbitration as well. So you've got signed the Singapore Convention, the establishment of commercial courts, but then what we also have is the establishment of the mainland Hong Kong closer economic partnership investment agreement, which really was a watershed moment for the development of investor-state mediation in China, because for the first time it introduced sort of detailed rules and procedures for the use of investor-state mediation with the support of arbitral institutions in mainland, but also in Hong Kong as well. And there's also a panel of investor-state mediators from a panel in the mainland and also in Hong Kong. So what you have is the establishment of a sort of a mediation mechanism for the first time in this kind of investment agreement in China. But what you also have is investor-state mediation training, which I know you yourself, Wolf, has participated in Hong Kong, co-organized by the Department of Justice and the Asian Academy of International Law, which has organized these investor-state mediation trainings in Hong Kong, which have included representatives from CEDA, that is the Centre for Effective Dispute Resolution in London, the International Mediation Institute, and as Wolf was discussing earlier, the Energy Charter Secretariat. So the picture from China really is one of support, of development. You've got, as I said, international commercial courts, the signing of the Singapore Convention, a mediation mechanism within the mainland Hong Kong close economic partnership, and also panels of investor-state mediators. And I think another thing that's worth mentioning as well is that leading arbitral institutions in mainland China have established their own mediation provisions within their arbitration rules. So if we look at the Beijing International Arbitration Center and CTAC, two of the leading arbitration institutions in mainland China, you can see the provisions for mediation in their investment arbitration rules. So what I think this all speaks to is really a China that is developing and promoting investor-state mediation and mediation, commercial mediation more generally, and with the Belt and Road in mind. I think China is placing itself as sort of an international disputes hub whereby investors have a procedure. There are the facilities and the infrastructure to resolve their disputes through mediation. So I think that's the picture for China.
Yeah, no, that's interesting, and you're absolutely right. CEPA, the agreement that you're referring to between mainland China and Hong Kong, which I think goes back to 2017, is actually a very interesting agreement, because it can very well serve, I think, as a model, perhaps, going forward, also for Belt and Road disputes. And as Joel said, we, through CEDAR and ICSID and the Energy Charter Secretariat, were very much involved in the training of the mediators, both from mainland China and Hong Kong, that are being utilized under CEPA. And that's actually a very good point, Joel, that you bring up, and that is the need for capacity building within the mediation structure that's being put in place, because it's well and good to have the rules, but you also have to have the mediators that are trained, particularly with respect to investment disputes, because this is a very different area of practice. These are not simply commercial disputes. So commercial mediators, people who have been trained to mediate and have mediation skills, also need additional training in investment disputes. And that's really what we've been trying to do through ICSID and Energy Charter and CEDAR, is to have a cadre then of people who are able to deal with these disputes, particularly as they increase, and there are more of them. We need people that are trained globally to be able to do that. And so this training that took place over a period of about 3 years in Hong Kong has been very critical to help build that capacity. And I'm certain that will continue in the future as well. It's also a matter of educating both the investors and the states as to the use of mediation, and also their counsels, so the lawyers who are involved in this, so that they all understand. So there is certainly still a lot of capacity building that has to take place for this to become part of the normal process, but that is certainly happening. What I think is also interesting, and I don't know how much information we yet have about this, but China has also spoken about an international mediation court, and there is a move to establish that in Hong Kong. Do you have any more information about that, Joel? Do you know what is currently happening?
Yeah, so it's kind of hot off the press, really. In 2022, the Chinese government proposed to set up a preparatory office for sort of an international. It was first described as an international mediation court to be based in Hong Kong. I think the Global Times called it an international mediation court, which is interesting because, as we've discussed, Wolf, the term court implies a kind of adjudicative process whereby a mediation institution is fulfilling a separate function. So the name court is certainly, it might be needed to change to something more neutral. But what we've had is that the Chinese government has itself made some formal submissions and proposed what it's actually supposed to be, which is this intergovernmental legal organization dedicated to resolving international disputes through mediation. And it is said, and I'm reading this from the press release, from the Chinese government is that it will transcend the limit of litigation and arbitration in which one side wins and the other loses, aiming to realize a win-win cooperation between the parties, which is of high significance for promoting world peace, security and development, etc. So I think this international mediation institution or organization will probably be the first of its kind in practice. I can't think of a specific international mediation institution of this kind ever being established. So China is really an innovator in this space, because the establishment of such an institution, will be one of the first of its kind, a watershed moment, and further demonstrating the support of the Chinese government for mediation. I think in a wider context, I think it's part of Xi Jinping's China's strategy to play a role as a global mediator. We recently saw the Iran-Saudi Arabia deal that was reached, and along the Belt and Road, there's been an awful lot of sort of a mediation strategy from the Chinese government to resolve these kind of disputes. So I think, the establishment of this kind of institution really speaks to a strategy of resolving disputes through mediation and dialogue, which I think is a positive thing.
Yeah, I think, Joel, this is actually very apt, because one of the areas where dispute resolution is just starting to be discussed is within the energy transition. And as we know globally, as we face, the climate crisis that we currently have, as we transition from fossil fuels to sustainable energy, this is going to be a massive change within society, within industry, and between states as well. And that will inevitably lead to different areas of conflict. And it's very important, I think, globally also to have these institutions that are looking at collaborative means to resolve disputes, particularly of that nature, because that's really the only way those types of disputes are really going to be resolved. State courts and arbitration aren't really going to be the mechanisms for energy transition disputes to be resolved. They're going to have to they'll need collaboration from many sectors of society and also states collaborating with each other to be able to deal with that transition. And so I think this idea of having an international institution to be able to perhaps bring these types of disputes to is actually very innovative. And I think that's the kind of thinking that we're going to need in order to also deal with these climate issues. So I think that's very progressive. I don't know, Professor Kong, whether you've had any questions from anyone, because I
Yes.
want to make sure that we do also answer any questions.
Mm-hmm. Thank you so much for your informative talks. And I do have a question. Maybe I can kick off the Q&A session by raising the first question. You have basically mentioned officials are reluctant to take responsibility in submitting a dispute to mediation, particularly in the bureaucratic context. Mm-hmm. So in the Chinese context, that might be also the case. Government officials might be questioned why you made such a decision in offering the solution, the settlement, or accepting the solution. So they might be reluctant to have the dispute be mediated by a third party. Particularly, they have to make the decision by their own. If it's an arbitration contest, certainly they don't need to make the decision because it's the arbitrator who made the decision. So this is possibly a very subtle atmosphere in the Chinese context, or even in the Asian context. So, what's your advice? How to what's your advice to promote the use of mediation in those countries like China?
Yeah. Well, I don't think, Professor Kong, that's only Chinese or Asian countries that face that. It's global. This has been a reluctance, I think, by state officials generally to make a decision where they might later be questioned as to why a matter was resolved in a certain way. I think that's even an issue in negotiating with states, not even in a mediation context, but just negotiating with states and trying to find a resolution. In my previous position, I was when I was within a company, I was often involved in negotiating with states, and negotiating with states is very different than with commercial parties, because there are a lot of other considerations the state has. I mean, there's also a political context, of course, in those negotiations, which have to be factored in. And I think it's important for the state. That's why I was mentioning the ECT model instrument, because the state has to put in place a framework for it to be able to negotiate, so that it's very clear who are the people who have the authority to negotiate and who actually signs off on the final decision. So the state official might be involved in the mediation and in the discussions and agree a framework settlement, but that still has to go then to somebody to be approved within the state. And if you already have that in place, and you know who you're going to and who has the authority, then it's much easier for the state official, because there's a process in place. And whenever there's a process, then it makes it much easier for parties to agree. I think the important point here is you get a much better resolution, whether you're the state or the investor, through negotiation and agreeing, rather than having a third party like the arbitrator impose a decision on you, because you don't know what that decision is going to be, first of all. And that decision might actually be a complete surprise to one of the parties, because as Joel was saying, there's a winner and loser in an adjudicative process. And the loser will never like the result. And maybe even the winner doesn't like the result either. So finding a negotiated process that works is always going to be better for the parties. And I think that's recognized certainly in what the Chinese government is doing. And I think if it becomes part of the process, then it's going to be much easier for state officials to utilize it.
Now we have two questions in the chat room, so maybe it's up to you to decide whether to answer.
Okay, let me see if I can. Can you, Joel, see? I can't see the whole question, but
yeah. So
I will read the question.
Okay,
so you can
Professor Kong.
Yeah, please. Yeah, go ahead. Joe, go ahead.
I think you
can have access to the question. Yeah.
I think we have a question from Nikki. Thanks for your thought-provoking presentation. I wonder what aspects should be taken into account in the process of building the International Organization of Mediation. So what type of aspects should be taken into account in the process of building it in Hong Kong? I'm happy to kick that off.
Sure, go ahead, Joe.
Yeah. So I think one of the main aspects of mediation is for the independence of the process and the independence of the mediator themselves and the appearance that they are independent. So I think one of the main aspects that should be taken into account in the building of this mediation organization is independence, impartiality of the mediators, and I would also say a robust procedure for the resolution of these types of disputes, and that's bearing in mind party autonomy, the interests of the parties, I think it would be a good idea that they have a say in how the process is carried out, because essentially their dispute. But really, independence, a robust procedure, and also a cadre of mediators who are equipped to deal with those types of disputes, because ultimately, as they say, an arbitration is only good as the arbitrators. Well, I guess the mediation is also as only good as the mediators. So that's what I would say.
And maybe
just, Wolf?
Yeah, maybe just to add to that, I think that's absolutely right, Joel. There's always a question of enforcement, and particularly where you're talking about cross-border situations. I think the Singapore Mediation Convention plays an important role there, because that deals with cross-border mediated settlements. There's still, I guess, some debate as to whether that would apply to investor-state disputes as well, but I think it does. And so I think there is also that enforcement mechanism there, but that's a consideration certainly that would be added to it.
That's great. We have a question from Dora, who's asked, thank you very much for sharing, it's very inspiring. May I ask Mr. Kumberg a question about the ECT? It seems to me that the modernization of the ECT goes well, and the model instrument you mentioned is really helpful. But recently I noticed that many countries plan to withdraw. What do you think are the main concerns and worries? I think that's a good question. I'll leave that with you.
Well, that's rather. It is currently an issue for the ECT, and the ECT is trying to modernize its treaty as well at the same time. And I think it's difficult to say what some of the issues are. I mean, they clearly, many of them have to do with what's happening with energy at the moment. And the concerns that as we move from fossil fuel to sustainable energy, a lot of the traditional agreements that are in place between investors and states will be affected by that. And so I think states that are members are concerned about potential claims that may be brought against them in the future, as they have to make changes themselves. And so that's the tension within, I think, the primary tension that exists there at the moment. Yes, we'll have to see how that develops.
So I wonder whether you are willing to pick one last question.
Yes,
that
is you go ahead, Professor Kong. You pick one for us. And
okay, so I will raise this question on behalf of my colleague. What do you recommend to our students as to how to become a mediator or lawyer in ISDS?
Yes, well, that's an excellent question, and I often talk to students about that. I think learning about mediation at the university level is very important, and increasingly universities are adding that to their curriculum and teaching students about mediation. And I think that's very important for universities to be doing that. So that's a good place to start. There are also other institutions, I know in China and also internationally, that have mediation programs that students could take. And then there are different organizations such as CEDAR that Joel mentioned before as well, that are involved in mediation internationally, globally. And perhaps very important, I should mention, is the International Mediation Institute, which is a global organization which is really devoted to mediation. You can find their website. You can join as a person who's interested, a young mediator. That institution, and you can actually then network with people around the world on mediation. So it's a great place to get information and to meet people. So International Mediation Institute. So there are different ways of getting involved. And I think as mediation becomes more prevalent in China and also outside of China, there will be many, many opportunities. And I think it's a great way for young lawyers to actually be effective in how they help to resolve disputes.
Thank you so much. And I know mediators' time is very expensive, so I cannot take more of your time. So I would like to thank you on behalf of all the audience, your excellent and informative talks about mediation, use of mediation in ISDS. Thank you so much, and I hope in the future we'll be able to have you again. Thank you.
Yes,
and
absolutely.
You will be very welcome at the university.
Well, I would very much like to come. Yes,
Mr.
meet you in person.
And Mr. Eman.
Yes.
Thank you. Yeah.
Okay, Joel, thank you very much. Professor Kong, thank you.
Thanks, Wolf. Thanks, Professor Kong. Thanks, everybody.
Bye-bye.
Bye-bye. Take care.
Yeah.